we in the Superior Court of Judicature in the High Court of Justice, Kumasi, AD 2026, which was filed on the 4th of June 2016. Not to say, every day, and I won't call file we are prem tobre abapan sima edria 9 12:40 p.m. and I registered in the stamp so then the signature ACC so. Mamia Akosua say was hybrid and a lawyer Kusi wasakeno wako akwakofa Kulendi at law lawyer Stephen Insia Opoku say ono eneme gira na nemu na ondi asem kai say Kulendi justice yoni Kulendi ono ya Supreme Court judge na nado dan kwakufa do boni din de be Supreme Court judge kese pa justice Kulendi so oyobi a usua mra di mra e wona na kufa do ni chambers anya asem ketwa nei na nakufa do kire na de ne ade a wa be Supreme Court judge kese pa e wo Ghana sebia na wo just appeal na amaso a we ne ba so na information a yetete e kire se eda no on the 11th of June no abusapeni lawyers any lawyer for aka no respondents no omo lawyers no nyade so mbekwa kopie mu wo court honum esan se wo mo kire se wo na se wo san lawyer wo mo si yo mate emrama ho kwan se san lawyer okoya amendment a emrama ho kwan se amendment it wo mo nyade so mbesi court on the 11th of June.
Oheneba Media for na efremu ayebo me say media royals media mu adehye no asebo ana semana amamla ni amani emu dwumadie Oheneba Media betenete enti amanfo muntie na nyado
abusuame mu akwaba mfamra Oheneba Media so bigidi se ho ye yenso ye ho ye pa ye bedi nkomo we breaking news a afei kra na ba system ni mu na ye se lumba nsem no ho ha ne mu adwe ho ne mu asan sori enyo ye bigidi se o follow ye ade bia me catch se lumba semi enya ntwae esanse afei kra na nsem na kese ye ho mu ebeba Mami Akosua se wa ye beka ya ansa na lumba yi beba so no de kodan court se eka court ne hwe no ka bi ma ne se onu nkuto ne ye Charles Kwadwofo so de lumba ne yere ebio Priscilla Ofori a friend Odobroni court no NCC no se didi kan onye yere na ontimi so enye kuna ema asase mi atwe ho da yere wo Kumasi High Court 5 no enamu ama temu ba se court ne gitum se Odobroni yere Akosua se wa so yere ema ada release account no court no ebotugu ye eno na Mami Akosua se wa ye se obesan afile appeal esan se atemu eba ye no na ne bo enyo so onu esusu se atemu a temu afo ne ba abontere no temu afo na yemfu so bebre ema na dance ne ade ogada de koma court no ebu na ni gusu nti na wo se wasan ye appeal na wo mu ebu asem na de ma no ne kwan bia so na busia ye nyina ye nim se na Dominion Chambers aye lawyer Kusi Williams ono ene da no ene na ejina mu se mranimfo de Mami Akosua se wa bra ye di court akobadi ni ade ehu appeal ne nhihia ne kosunya na wono mu a ene hye mu nsa breaking news abeka ensa ne se Sabre Mami Akosua se wa agi case ni nyina afri lawyer William Kusi nsem de akoma Kulendi at law ene ne partners Sabre de lawyer fofoforo ene ebeso asemni mu na omagina mu de akama Mami Akosua se wa lawyer Stephen Insia Opoku wo Kulendi at law womo ena ebeso asem no Sabre de lawyer William Kusi Mami Akosua se wa na pe hu nsem ni nyina no eni ni nsem ebiemu na yasake no anase ejifri ni nsem boko what is the inside details menemo ba beche to adam abaso a bobode se obe like here ma me share na obi ensanka bi for comments na ebegu ase na bibia anya kama me san case so se Mami Akosua se wa e the release bibre akodan court na wo sere court ne se yedi kan na lawyer for no wo sesa wo no mo ebio appeal a wo ba be ye no wadi kan asubmit ensem ni bebre na obesere se court no makwan na onye mu nsachira san se wasan lawyer for no de wo so sachira ne nsem ni mu kakra se be ye na asem ne betimi akwama na ensem be no de akodan court no mensa ekura 19 paged document a wo court no dim na lawyer for de ma abusapeni Kofi Owusu de wo court nkrata no so abusapeni Kofi Owusu afin so Priscilla Ofori and transitions funeral home wo mo lawyer for ensaka no me so me nsaka bi ha me mo ebe chesansim nya ne ehunu de ebe koso court Mami Akosua sa wade nti e no sesa ne lawyer efri lawyer Kusi e de call lawyer Kulendi anase Kulendi asolo lawyer nsia ode koma wono mu eno so no ebidi mu enchire muti mu ani eni nsem yachi de omu bia obete ne ne wo ha no mo ya na do comment abase de kan share na obi ensanka bi midin ede nkofo da asrebre emfase da please ema tap send wo mo ene bo echi dom ene adontim yetimi ede sa ensem etise ede abra obusia yemo remwe enti krata da bani mu obusia serem di kan no krata na da screen so no na lawyer William Kusi wono ewo Dominion Chambers no Kumase wono na handle Mami Akosua Serwaa ne court nsensem kuna ye ne yire ho nsensem nyina ono a na handle ma ye nyina hunu ba bia ensem no kokkowie wa bra court pie mu Kumase High Court 5 a Justice Dorinda Smith ata no ene temu afa otena adwemu ma na odi na temu ba ye chechire mu de enti asem no obua editi Mami Akosua Serwaa na anase wogie odobro ni tum se wo yire ne ade nyina ode nchechim ba ya ene it didn't sit well with a lot of people are one more aside with Mami Akosua Serwaa mo mtre say sebia temu afo nde ba ya na webu ntenchia enu nti no mo ebe file appeal na wo mo akọ amaya atemu afo ni bia beka ho court kesie mu appeals court na atemu afo be se miensa aba betena asem no so no mo ankasa gino mo ni din ahwemu hunu se asem a ya Justice Dorinda Smith di ye no ehu atemu de ba ya na ne kwan so no anase ntenchia bi ko so mfom so bi ba ya na se din enu nti ena ya appeal court na busia me be kan krata yi ba ko se twere kunkum asem na ye nyina ya bomodi de ne edi ekire ne agene ye ne ahwemu de enti appeal no sa kire ebam de enti Mami Akosua Serwaa na lawyer force san wo mo so da ben na ekoso wo court fa court ben na ebekoso ni nyina no ubete e wa ha na de kan we in the Superior Court of Judicature in the High Court of Justice Kumasi AD 2026 which was filed on the 4th of June 2016 na say enre day ya na wo ko file ye awia prem to bre abapa ho sima aduanan 12:40 p.m. and registered in stamp esi so den sa ehase den signature esi so na de onie o se suit number GJ 12202026 suit number GJ 12/20/2026 plaintiff / appellant / applicant Mami Akosua Serwaa Fosu chese an address edaso versus number 1 Abusia Penny Kofi Owusu Ebuakwa Kumase 2 Priscilla Ofori aka Odobroni Accra 3 Transitions Funeral Home some address ka ho Enterprise Funeral Services no ha cho Asori Junction Atomic Road Accra enipa mi ensen anase enipa mienu ni dwumako e ka ho etos mi ensen na ye defendant musukoyi omo ano net year notice of motion application for leave to amend notice of appeal na chese wo ma file motion no omo de kokko ekosre court ne say omo pese omo amend wo mo appeal no until they are applying for leave to amend the notice of appeal na tie de o say take notice that this honorable court will be moved by counsel for and on behalf of the plaintiff, the appellant or applicant, hearing, praying for leave to amend the notice of appeal filed on 1st December 2025 to substitute the grounds of appeal therein stated upon the grounds contained in the accompanying affidavit and for such further order or orders as this honorable court may deem meet. Court to be moved on the 11th day of June 2026 at 9 o'clock in the forenoon or so soon thereafter as counsel for and on behalf of the plaintiff, appellant or applicant may be heard. Dated at Malo Chambers, Accra, this 28th day of May 2026. Signed by Stephen Insia Opoku, Kulendi at law, solicitor for the plaintiff, appellant or applicant. And the license number is also ne stamp is so. Now, the application nyina say court no kire say nyankro portrait dan po yadom a eya bosumi e wo mi de to so edu ba ko wo Kumasi High Court anopa nonkono pepepepepepepe anase firi anopa nonkono court no betena ase de enti a court no tena ase nyina ne say eya lawyer for e de Mami Akosua Serwaa eye Kulendi at law lawyer Stephen Insia Opoku kire kwesere court ne say court ne ma kwan na Mami Akosua Serwaa ne appeal a okọ file ye afi atwa mu eye December 2025 no court ne nyama kwan na omeye nsacharaye wom omeye sesa wom a enu nti no wo mo de eye affidavit support ye enti nyame adom a on the 11th of June no court be kwa asetena na de enti omo kɔ srese court no nya eye sa nsacharaye no enu nie na omo srese de court ne be ka no ene be ye ho enti yenkɔ na yenkɔnkotie affidavit no enseme wom na we no omo serve ye no omo serve the first defendant a no asan first respondent no so asan ye respondent 1 anasa ne lawyer na lawyer Fati Ali Yala of Baba Jamal and Associates Accra ono na ejina mu de ama abusuapeni Kofi Owusu said the court nkrata na woso. Number 2 second defendant respondent ene ne lawyer lawyer AK Osei Owusu a ono wo Cardinal Law Group and one crime ono ejina mu de ama Priscilla Ofori Odobroni. Number 3 Transitions Funeral Home one lawyer lawyer EJ Bediakon a ono EJ Bediakon at law Kumase ono so na ejina mu di amom enti wo ma serve wo mo ama wo mo ensa kan sa ensamankra ya wo mo kire se eno no mo koye na affidavit ni mi abusuan na da so no ye hwe de wo mo affidavit plaintiff a oda so Akosua Serwaa fosu ne address wo Swester we no German kasent mo fan cheme enti na address ni nyina ekowiem se wo Germany versus abusuapeni Kofi Owusu abu akwa Kumase number 1. Number 2 Priscilla Ofori Odobroni number 3 Transitions Funeral Home also crime na abusia affidavit in support ni we so no one file on the 4th of June 2026 12:40 p.m. Land and Human Rights Court Kumase a registered in sa esisu se pan na o say I ama ampon ajimai prempe of 10A Bote Avenue Airport Residential Area near Nyaho Clinic Accra in the Greater Accra region of the Republic of Ghana make oath and say as follows o say me ama ampon ajimai prempe me house address 10A Bote Avenue Airport Residential Area I no ben Nyaho Clinic one crime crime pumpini mantemu Ghana asase so yi mi swai edin se the kind that I am a lawyer in the law firm of Mrs. Kulendi at law, solicitors for the plaintiff or the applicant, hearing after called the applicant hearing. Enti was say mi swai edin se me ama ampo ajama prempe me emranim ni edema applicant mami Akosua Serwaa na me ye dwuma Mrs. Kulendi at law womo law firm chese me na me solicitor edema mami Akosua Serwaa. 2 that I have the authority and consent of the applicant to depose to this affidavit for and on her behalf. Should say me onipa wo gina mu say applicant and I say plaintiff no ama me kwan ama me tumi say mitimi de mensa hye sa affidavit yi ase anase na wo say me gina mu sa affidavit yi edema no. 3 that the content of this affidavit unless otherwise stated are matters which are within my personal knowledge, information and belief by reason of instructions and documents received by our law firm in the course of conducting this suit. Should I say and some what affidavit mu nyina no me swai edinsia kantam say the woman no ebia na age say yanka yensem a ye de abedan ye law firm ye plaintiff de abedan ye law firm say ye ni hudwuma enti me firimi amadwene mu ene me nyansem ni nsem e de ma me ene magina so akro kire sa affidavit nkrata yi. The also 9 that at the hearing of this application counsel for the applicant shall seek leave of the honorable court to rely on all processes filed in this suit as if same have been reproduced in this affidavit in extenso and sworn to on oath. Should say yes application branim ni a ogina ho de ma nipa wo sere se court hwe no nyensiese mami Akosua Serwaa ne branim ni ebe sere court no say court no entie nsem mo de abanyina na enum na wo begina asoi sa affidavit na ye de bibia to bia wo se da. Number 5 that the applicant commenced the instant actions in the High Court Kumase on the 2nd day of October 2025 against the respondent, seeking the reliefs endorsed on the writ of summons and the accompanying statement of claim. Say enipa wabo charge anaso obo kwadu e mame Akosua Serwaa no ehye sa eye appeal yase October bosome da na etoso eye mienu mofa chemi October bosome da etoso mienu no share sa eye court nsem yase se court no hwe na nka woni asem ma no e won saman krata wode saman woni a wo ye respondent no tin saman e oso nyina no mame Akosua hyase 2nd day of October 2025. Now ochiremu biem say that after trial the trial court delivered its judgment on the 28th day of November 2025, whereafter the applicant, dissatisfied with the said judgment, caused their lawyers to file a notice of appeal on the 1st day of December 2025, attached hereto and marked as Exhibit A is a copy of the notice of appeal. And you see, November, Bosumi Dane Toswa during of 2025 mu. Ena eya asema mame Akosua Serwaa de court court 2nd October 2025 no ehu atemu obaye na so ne bo anyu atemu no so atemu on de baye no anso nani na ne bonyo so enu ti wo share na lawyer fo ema December da na di kan 2025 no wo mo ekọ file eye appeal enu ena mede aka sa eye krata yi hu se Exhibit A adanse edi kan no enti court no enre sa Exhibit A the to so say that the applicant further caused her lawyer to file additional grounds of appeal on the 3rd of February 2026, attached here to and marked that Exhibit B is a copy of the additional grounds. Let's say, a year February, Busumi and Womo, neither told me and son, applicant, Mame Akosua Serwaa san share the lawyer, Emmanuel Sanko file additional grounds. The advance here for Froko can, and appeal no, Emmanuel Susuno, Yatuni didn't say Exhibit B, I dear Kahon. Ebio, that the applicant subsequently engaged our Stephen Insiopoku to prosecute the appeal on her behalf, following which a notice of change of solicitor was filed on 22nd April 2026, attached here to and marked as Exhibit C is a copy of the notice of change of solicitor. Let's say April bosomi da ne toso aduonu mienu afiya mu enna Mame Akosua Serwaa share say ne lawyer fo a ejire mu di asem na mam no oye mu nsakyra ya osesam enu ti o share say eye yan kasa ya de nyina Stephen Insiopoku a no Kulendi atlo me pacho said the krata ne kan ya de nyina na me kan eye said o chon awa Stephen Insiopoku na che say Kulendi atlo wo mo lawyer ni Stephen Insiopoku enna Mame Akosua Serwaa si we ni so o mesi na e court nti wasesa ne lawyer a na lawyer Kusi we na firo de Stephen Insiopoku o Kulendi atlo enna eba that following a review of the grounds of appeal canvassed in the notice of appeal and the notice of additional grounds, it has become necessary to seek leave to amend the said grounds in order to ensure that same conforms to the rules of the court and to ensure an effective and complete adjudication of all issues arising from the judgment. Enti omo hwe eye hwehwemu ni ade appeal omo be ye na ho adanse ekrom ni ade na court no mra ne makwan se won betimi asre na ensakyereye a omo pese omo ye no omo ye nyina including a lawyer for a wosesan wo mo ene adanse a wode ekoka ho no nyina no court no makwan ma otumi ye. Number 10 will say that in particular some of the grounds of appeal alleging errors of law were not particularized as required under Rule 8 Clause 4 of the Court of Appeal Rules 1997 CI 19 80 what should I say ohia enfumso kakra bae kire say Court of Appeal no enfumso bi a omo ekoya appeal wo mu no bae no kire say e wo so mtimi esa kire etu hwe Court of Appeal ne mra mu a Rule 8 Clause 4 ewo appeals court ne rule mu ene 1997 CI constitutional instrument 19 no ema kwan so mutimi yes answer kire no. 11 say that there are also new grounds of appeal that the applicant wishes to canvass before the Court of Appeal for adjudication. Na che say wo mo adanse foforo ho a o person mo de kan wo mo appeal no say beboa na wo asem no ebetimi Akosua no ne ho atemu etimi aba. That the applicant therefore seeks leave to amend the notice of appeal and to file an amended notice of appeal that embodies all grounds that the applicant proposes for adjudication before the Court of Appeal. Enti applicant Mame Akosua Serwaa everywhere so be sansa kire ni nyina nti na ode saa nkaboi ma court no ene woni ekika hu nyina se be no betimi agina so no mehu nimde ombenya ho nimdia information say appeal be say koso na sachire say na koso wo mu that this leave is sought in good faith and in interest of justice to permit the applicant to present her entire case before the court of appeal for determination. Just say sa kwan a omo srei ebeboa ama mame Akosua se watimi de na asem ene dadanse nyina akoto court no anim said the beye no betimi agina so abua asem no ne kwan so that the respondent will not be prejudiced in any way as civil form 6 has not been issued and the record of appeal is yet to be fully compiled and transmitted to the court of appeal. Let's say ebasa womo ye enyanofo no abusuapeni Kofi Owusu Preslofori ena bio transitions funeral home no we meye prejudice bia emfa mo esanse afa kra na enkrata asem ne ade nyina no womo ye ede akwakoto court no anymore. That in the circumstances, I respectfully pray that this honorable court exercises its discretion in favor of the applicant and grants her leave to file the amended notice of appeal. Wherefore, I swear to this affidavit in support in good faith, sworn at Kumasi this 4th day of June 2026, before me, Commissioner for Oaths, Maxwell Mensah Brimpon, Commissioner for Oaths, Edrum Kumasi. Enti, oche se, was rest ya court na makwan, na mame Akosua Serwaa, enti minya sansa, chile nyina se lebe boa, na atemu netimi akoso, ache se, Commissioner of Oaths ahwe, ama deponenti, no ye, ama ampon, ajimai prempe, etimi, yesa, ensisa, nyina ode akodan court, no, ena court, nebe koso asetna, nyankro point trade ampon, ya drumwa, on the 11th of June, na court no ebe koso asetna. Na ebusuya, here certificate of exhibit, and also na tuasui, womo ede akodan, mame Akosua Serwaa ede akodan court no. The other kind, Osi I, Maxwell M. Bempong, Commissioner of Oaths of Kumasi, do hereby certify that the underlisted has been exhibited to the affidavit sworn before me. Enti exhibit omode call ye and sisakraye wa appeal ni muno. The kind exhibit A no a copy of the notice of appeal. It's notice of appeal no copy. The toss me a copy of the additional grounds of appeal. Not just enyina so a womode call akoya appeal no ehun kai ho no exhibit B. Exhibit C no a copy of the notice of change of solicitor. Not just womo catch record no so womo sesa womo emre nimni eno so de ho adanse enso akọ. Exhibit D no a proposed amended notice of appeal. Not just eno so no appeal no a womo ko file ye wo December no any February ni mu no wo person science achiraye wo mu eno nti no on the same proposal and so akodan court a commission of votes agini nyina tum de ne stamp person so pan a eno so de akodan high court of justice wo Kumasi na de ho no enie notice of appeal no enie abusuya enti hwe a Kumasi Ashanti region in the Superior Court of Judicature Mame Akosua Serwaa fosu ena na address eka ho ewo Schwester Germany ona a plaintiff ena ebio abusuapeni Kofi Wusu abu akwa Kumasi Preslofori aka Odobroni Accra Transitions Funeral Home aka Enterprise Funeral Services Hacho Asori Junction Atomic Road Accra womo emiansa ena defendants na ohwa womo filing on the 1st of December 2025 enuniye wasi please take notice that the plaintiff or appellant hearing being aggrieved and dissatisfied with the judgment of the High Court Kumasi, more particularly stated herein and contained in the judgment of His Ladyship Justice Dorinda Smith Arthur, sitting at the High Court Kumasi and dated on the 28th day of November 2025, do hereby appeal to the court appeal against the decision upon the grounds set out in paragraph 3 and will at the hearing of the appeal seek the relief set out in paragraph 4. Enti when in a normal cap Kusi so say, Mame Akosua Serwaa chese ne bon yo atemwa Justice Dorinda Smith Arthur de ba 28th day of November 2025. Nti almost say court no hwe na omo kabi na atemwa de ba na omo boni nyina ntugu na the reliefs are na ono hwehwe no court no grant inform the reliefs na they say ono nkuto na the legitimate and the legal wife of Charles Kwadwo Fosu na face na kuna ye ho asem so eka ho court no hwe na onka bi informa no na TA or say the plaintiff or appellant further states that the name and the address for the service with the jurisdiction of the persons directly affected by appeal are those set out in paragraph 5. 2. Part of the judgment of trial court complained of 1. The whole of the judgment of the High Court, Kumasi, dated the 28th day of November 2025. Not just say, Atemwa, court anybody in Yano, court no fact you pay 17 time won't trim. Esan say Nebo and no sassams no more. And in a Swania down here, I trust and or no my Akosua say one that's what better court no. Neither hope face and Kawasa court no, a can be man na court no fuaso and son. And a court na you sent court to a year of appeal no interest Atemwana justice during the Smitata Ediba anymore. Ebio was a grounds of appeal. The High Court erred when it held that the marriage certificate, Exhibit B, B1 and B2 was not admissible per se. Not just say, or say, High Court no, am from Swaka pass, Mammy Akosua say, one marriage certificate or the buyer, then what to the say Exhibit B, B1 and B2 no court no anyan to mu, court no yam from so, it's Court of Appeal, and share now one yen such a Ebio, the court erred when it held that Section 161 of the Evidence Act is a condition precedent for putting weight on an admitted document. It's also court in high from such say Section 161 Evidence Act no a condition as a precedent say one more day adance any mu drone na no gusankrata also there be court na yes am from so Court of Appeal emoni nyina ntumu. 3. The court erred when it held that the evidence adduced by the defendant was more credible than that of the evidence of the plaintiff. Not just say court ne ka say adansi a defendant here ebusuapeni Preslofori Odobroni ɛna transitions funeral home ɛde no na mu odu chen ono maame Akosua Serwaa ne de no wo say what court ne is inform so pa ente sa anti Court of Appeal entwamu na onye sa ensakraye no. ɛna 4. Additional grounds will be filed upon receipt of the records of appeal. And I just say one more at the dance for any in a soft for besan akaho wabra a Court of Appeal nebechi one more records no atumu. Now reliefs no fall in your say. Relief sought from the Court of Appeal that the whole judgment of the High Court be set aside and judgment be entered in the favor of the plaintiff. Enti Court of Appeal ni say High Court na temu de ba nyina no wo mu twam tinton tan se the medical aka no na wo mu ni asem no fama ono maame Akosua Serwaa. 5. Persons directly affected by the appeal. What should I say? One more appeal we ebe affect some the kan yabusapeni Kofi Owusu ebu akwa Kumasi. 2. Priscilla Ofori aka Odobroni Accra. 3. Transitions Funeral Home aka Enterprise Funeral Services Hacho, Asori Junction, Atomic Road, Accra. Dated at Dominion Chambers, Edum, Kumasi, this 28th day of November 2025. Lawyer for the plaintiff or the appellant, lawyer Kusi Williams Esquire and Nidin Eshasi. Enti we no me adanse na omode aka ho omode kodan court ne say court no hwe na wo mo enka bi inform nti additional grounds of appeal ni nyina no so no e o manu exhibit B na additional grounds of appeal no so nie eno the judgment is against the weight of evidence adduced at trial. Now say atemu a justice during the Smitata de baye no wo hwe adanse a omode bae na chese atemu no ene ne mfa kra ene ne mfa esa se adanse mu du cha atemu na temu afo na ede bae no the tosumienu the court erred when it held that foreign law as a question of fact can only be proved by calling an expert witness. Na chese court ne enfom so se opeso kire se amanonimra se yebetimi approve na expert nko na yebetimi ayesa age a free expert witness eba ema ne be di adanse o se dabi court no yemfom so ho etire no so Court of Appeal hwe no fa pensim tintontan na ontwa sa asem ni mo. Number 3, the court erred when it rejected Exhibit B, B1 and C upon consideration of Section 5 and 161 Clause 3 of the Evidence Decree 1975 NRCD 323, thereby leading to its fatal presumption that Ghana's ordinance marriage was same to that of the German civil marriage. Or just say, court na from so kese pa say, obo wo madan say B1 and C no to go ye say na court na adwene mu ni susu mu person ka say Ghana ya ware no ye mrema ware no ne Germany de na ye pe wo say ente sa da ente sa de biara da enti no court no montumu na particulars of error ni wo kire say de ento mu gina so akasa ni 1. Save for a brief moment of courtroom inspection, unchallenged evidence of court proceedings showed that no reasonable opportunity was given to the defendant to investigate an authenticity of the aforementioned exhibit due to the court's haste to meet trial timelines. Or just say, na court no dia ho prepare se court no pentem say obetimi adi asem na wienti no. Wo ma defendant no kwan. Wo mo be yi omo no abusapeni Preslofori ene transitions for the kwan say wo mo kran no enkonko authenticate enkrata mo Akosua se wade omo am mo kwan mo ma ahie. Eti omo no omo ye defendant na ntimi kran me ka say omo authenticate sankrata ne ti dey na court no e dey am prepare ebo wo mo marriage certificate no to go here. B. Or say questionably, the courts having deprived the defendant reasonable opportunity to investigate the authenticity of the said exhibit, fatally endorsed and overly relied on the erroneous arguments by counsels for the defendant, thereby resulting in erroneous conclusions by the court. Just say, court no wa ma kwan amomo antimi authenticate nkrata no. Ena omo asem ye lawyer for na ejina mo defendant na se won be kan ye no court na dey ahopepreje tu mu o se wo ye ne sa enye yie eno na ma court no etimi de sa atemu asebe e attention no e de ba ye eti court of appeal re no mo san asem nsu entugu that if reasonable opportunity had been given to the parties to investigate the authenticity of the said exhibit, the trial court would have ordered the said exhibit to be treated presumptively authentic and would not have come to the erroneous conclusions and findings it arrived at. Enti o se court no ema kwan ema parties no defendant and plaintiff ni na no omo hwehwemu authenticate adanse on by na enka adanse on by no ka court no hwe emu saa asem no atemu no by ko emu saa attention no eno nso ni asem omo de aba. Now o say the learned judge misdirected herself in law by treating the plaintiff's inability to authenticate her German marriage certificate as a choice within her control. Just say, Mami Akosua Serwaa entimi an authenticate marriage certificate no. The more for na yem from so kese pa say what this sa so de neto Mami Akosua Serwaa so. Ba ne sa enye mra. Intina no so court of appeal no hwe no ka bi. O say particulars of Miss direction dey ti omo ka say na enye Mami Akosua Serwaa na wo say court nche na so authenticate marriage certificate na ni ene ne say dey kind. The court directing plaintiff's counsel to have the said German marriage certificate to be authenticated without giving reasonable time for Ghana's embassy in Germany to execute the said certification of genuineness of the signatures on the said certificate. Just say, court na shada amu mbre. As na court ndi prepare na print em ebu asem no. It wan shada amu mbre ma Ghana ni embassy o Germany entimi anje enkrata asem a edi adanse na di mu ni nyina wa ma kwan amu anye. B or say, hence, by so doing, the court expected counsels for plaintiff to compel the Ghanaian embassy in Germany to expedite its own administrative bureaucratic procedures in the authentication process outlined under Section 161 of the Evidence Decree 1975, NRCD 323. Just say, court no emane koye say, Mami Akosua Serwaa ne lawyers no enkwahye Ghana embassy wo Germany na wo mo enya ade aho pepre kwan so nso wo de mre ene mra na ye adwuma wo mo kwan processes bureaucracies wo de adwuma ese na court high court ne hye Mami Akosua Serwaa ne lawyer fo na ma ase wo de pressure bi akoto Ghana embassy wo Germany so no ye ne sa na enye ye sanse wo de hyehyeye ene ye adwuma ebi wo say that a fair-minded court upon issuing such directive under Section 161 of the Evidence Decree 1975, NRCD 323, would have ordinarily waited for the said authenticated signature to the marriage certificate to be ready amidst the court's attention drawn to the hardship in the authentication process by counsels for plaintiff. She say, "Ka o de ka o court no kwan o de said na wo pen na o say omo authentication no was a court nya botre twen Kusi say authentication no signatures no ready e betimi aye crowd be ready aba court na nya sa adre na mom tina court na ready say nka wo mo Mami Akosua say lawyer for na lawyer Kusi na enya sa adwuma na o che say there bi wo mo yo no sa enye yi enti o say sa adre no na che say court no anye fair minded to wo mo say be court no na adwene say wo bu na ni egu nema bi so a wo anye fair to Mami Akosua Serwaa ene na lawyer for that the learned judge unduly hastened to give judgment by refusing to accommodate or even meaningfully inquire into the process, that is, direction for certification, she has set in motion under Section 161 of the Evidence Decree 1990. Or say, temwafoi prene hododo epre no de atem wo bae wa bra wa ma kwan ama kwan ya fa so authenticate certificate ni ade no wani saa nsem nyina so hwe ni nyina wo mra mu ka kwan ya follow ni nyina no ti mafo ni bu na ni bu so ani saa mra ne so enti ni nyina no court of appeal hwe na omuntumu. The misdirection infected the entire proceeding, rendering the entire judgment as having sacrificed procedural fairness for hasty record time judgment and vitiating orders made therein. Till just say, Sawe Nano, mane koye say, wabu emran komu, wabuni dichi, emma, a quan of us also for fast would dear 7 bokono, while Nenesa name or the pre and in temper and a your sadian. The court erred when it held that a law firm's clerk was not fit to answer an interrogatory because he was not the lawful attorney of the plaintiff. Just say, court ni from so kese pa say, I want my court to catch it. Ama bua ensem bi esan say ono emra enhye no say ono ene beye lawyer ni e de ama eye plaintiff mami Akosua Serwaa no court ni esan from so no esan say mrem na wo sen ko makwan e ma court to catch no e be isa ensem na no. The court erred when it held that counsel for the plaintiff had admitted in open court that the original certificate as was presented was an extract from a family book or diary and therefore not proof of a civil marriage between the plaintiff and the late Daddy Lumba. Chere say court ni yem from so kese pa say obeka say marriage certificate original certificate o mo de ba ye no no extract of a family book and I said diary enti court ni so onyin tum say no chere say mami Akosua Serwaa the late Charles Kwadwo Daddy Lumba ware wo mra kwan so say what court ni yem so pa say court ni ka asem no enti no so court of appeal enhwe sa asem no montungu na woni asem no mami Akosua Serwaa na tie o say particulars of error and so na oye no e na wo bobo so no say the court made a fatal and wrongful deduction from the explanation plaintiff's counsel rendered between the original marriage certificate and the said family book, which were presented to the court for comparison, thereby leading to a defect and an error in the judgment. Say court ni from so the original certificate about now court be kasi there be any family book court ni from so pass and say plaintiff no do broni abusapeni any other lawyer no and omo de buy say we na family book. Now so court ni abotre hwem ko be hu say we authentic marriage certificate free Germany aba. By misconstruing plaintiff's counsel's explanation that in Germany, the original marriage certificate, which was presented to the court, is extracted or generated from the family book, which is the source document, the court, by itself, misguided understanding without seeking clarity, collapsed the use of the plaintiff, thereby occasioning an injustice. Say, almost catch the court, say, ukwa Germany, one more authentic certificate, na extracts from the family book, no, omo ntia say dey tia court ne se chenchena chen ente sa ma court ni bu asem tia mami Akosua Serwaa enti no so court of appeal enhwe o say the court erred when it held that Exhibit G series rather supported the case that the late Daddy Lumba married the plaintiff customarily and not otherwise, which according to the court was more consistent with the admitted evidence on record. Just say ye be ka say Lumba ni Akosua Serwaa ware wo mra kwan so na say court be ka che say oni mami Akosua Serwaa mami Akosua Serwaa ware wo amamre kwan so nkwa de na court na enfun so pa sansa dance enkrata ne me de be nyina kire say wo ware wo emra kwan so no so court na enfun so pa and the particulars of error no osan to say the trial judge consciously and erroneously distorted factual statement by inserting words into the statement of the late Daddy Lumba, thereby basing her conclusions on a non-existing fact that the deceased married plaintiff customarily. Just say, court ne sheda buapa and from SIM from so beautiful. Just say, woman that didn't say much Daddy Lumba, no say Daddy Lumba ware odobroni. Yes sir. Na oware mami Akosua Serwaa customarily. Omo che say yes sir. Enti no court na kopen nsem de share Daddy Lumba no. Daddy Lumba nkan wo ba bia da. Wonka wo ba bia da. Enti asem a lawyer Kusi en na pamfo chiro yi ni ansa na ensakane. Enti yenkoy o say unchallenged video evidence of the said Exhibit G series neither spoke about the payment of any head drink nor inferred that the late Daddy Lumba married the plaintiff customarily. The trial judge nevertheless inserted these words into the video and relied on saying to reach her conclusions. I just said, almost they are dancing video evidence by. I just Daddy Lumba nka say o ware mami Akosua Serwaa wo amamre kwan so nkuto. Enti woman dem dey trial judge no eboapa antie say video ni mu nsem na ono a edane ensem no na ye omoanwa. Ebio say that the above mentioned non-existent and erroneous fact formed the basis of the trial judge's conclusion that the deceased married the plaintiff customarily only. She say, esan say temuafo no wabu na so wabu nuagu na so mu na ono anim de ohwehwe nti oyɛ saa no ene ma ekoba ese obebu ase da lumba no lum oware Akosua Serwaa wa amamre kwan so kwa but ente saa. Di no say that the reliance of the non-existent fact in the said exhibit G series being an error assumed by the trial judge and relied upon by some constituted a miscarriage of justice. Not just say the temuafo no ekọ gina saa asem ne kwa so eka say lumba ware Akosua Serwaa wa amamre kwan so kwa no ya de a chese wa ma atentene ni anya dwuma wo bua atentia that the court erred when it held that second defendant was validly married under Akan custom in April 2010 by the late Charles Kwadwo that Lumba when there was no evidence on record to support it. Chese court ni enfumso kese pa so be kan say an odobroni Lumba ware no April 2010 wa bra na adanse bia ni ho man timi afa adanse bia ma mekire na chese court no aye enfumso kese pa chese enya asem 20 wenum ni reliefs a omode ekoye ene ebi akeka ho omode koma court ne say enka court no enhwe na no mo gina so de aye wonum appeal na eno achi na Kulendi at law de eye enkrata afoforo akodan eye court ne say wo mo sre de wo mo hwehwe nie enti de di kan wo matesa wo mo mra nim ni tie wo say take notice that the plaintiff or applicant herein has this day appointed Stephen Opoku Esquire of Mrs. Kulendi at law, whose address for service is as below, as a new lawyer in the stead of William Kusi Esquire. Kulendi at law, number 10A Bote Avenue, behind Nyaho Clinic, Airport Residential Area, Accra. Solicitor's license number and date EGAR 00051/26, 19th November 2025. Dated at Malo Chambers, Accra, this 20th day of April 2026. Enutino, womo akwa service abusuapeni Kofi Usu wa wabu akwa Kumase, Preslofori AK Odobro no one crying. Transitions Funeral Home, Aye Enterprise Funeral Services, and Waha, Sorry Junction, Atomic Road, and crying. Say no, Mamia Akosua Serwaa say lawyer Kusi, onyane lawyer Bill, or the Aye Kulendi as law, Aye lawyer, Aye friend, lawyer, Aye Insia Stephen Opoku, and Eba Aben lawyer. And what she Omo proposed amended notice of appeal in Sunye. Say amendments no mo de ba no e wa pa ba benya da aja kenkan ni na eye ma cheche mu achem na mo suma hu de wo mo ehwehwe se wonum enye. Also take notice that the plaintiff or appellant hearing being aggrieved and dissatisfied with the judgment of the High Court Kumasi Quorum Her Ladyship Justice Dorinda Smith Arthur dated 28th November 2025 hereby appeals to the Court of Appeal on the grounds set out in paragraph 2 and will at the hearing of the appeal seek the relief set out in paragraph 3. The plaintiff or appellant further state that the names and addresses of the persons directly affected by the appeal are set out in paragraph 4. 1. Part of the judgment of the High Court complained of the entire judgment of the High Court Kumasi dated 28th November 2025 and also the grounds of appeal. Number 1, the learned trial judge erred in law when she held that the plaintiff appellant failed to prove the existence of a valid monogamous civil marriage contracted in Germany between the plaintiff and the deceased, Charles Kwadwo alias Dad Lumanti. One more catch the court and say, Sabre, one more episode in such a cacro appeal. Did it kind? A year appeal on person and say court no appeal on person and court no share not a temwa justice, her ladyship. Dorinda Smith Arthur Edinburgh 28 November 2025 won't come. Nina won't come. It was to be Temuafo ne yemfomso kyerɛ sɛ ɔbɛka sɛ adanse bia no kyerɛ sɛ maame Akosua Serwaa ne Charles Kwadwo Delumba ware wɔ mmramu ɛwɔ Germany anu ɛwɔ mmrakwan so a ɛne na Temuafo no yemfomso kɛseɛ pa enti no so no sakra mmra na tie particulars of error nie or say the learned trial judge conflated proof of foreign law with proof of the fact of the ordinance marriage contracted in Germany. So say Temuafo no wayemfomso kese pa se wode eye amanone mra ebe ya dance say no e kire say maami Akosua Serwaa ne Daddy Lumba anware o Germany no be proof o say de mfumso kese. B. The learned trial judge failed to appreciate that the evidence led by the plaintiff or appellant, including evidence of cohabitation, that is public representations of the deceased, eyewitness testimony, photographic evidence, issues of the union documentary evidence tendered by the plaintiff, and the embassy correspondence from the German embassy in Ghana substantially corroborated the existence of the said ordinance marriage. Let's say, temwafo no bunani guso bua pase onya danse maami Akosua Serwaa na lawyer for the baye enfoni of the baye videos ahodo adanse fo amdo amobaye ebedi adanse Lumba ne na warrior hu videos documentary ni niam omde gu nkrata so nyina baye the German embassy wo Ghana enso de gu nkrata so baye lawyer temwafo no sheda boapa bunani guso anya ntum na chese waye enfumso kese pa ebi o say the learned trial judge misdirected herself by treating alleged deficiencies in the authentication of the foreign marriage document as conclusive proof of the non-existence of the marriage itself. No, just say, temwafo enfumso pa say, the edi kan say enfumso kakra bi bai wo mo marriage certificate ni ade omde bai no enfumso kakra ba ho enso say enfumso aba ho kra na no kire say aware bi ankoso enti temwafo na enfumso pa wo mra mu enti ho so court of appeal no hwe. The learned trial judge failed to appreciate that the plaintiff, appellant, bore a burden to prove her ordinance marriage on a preponderance of probability, which said burden was met by the overwhelming evidence on record. Say, what for I am from so? Why you from so pass? Plaintiff no, where Maami Akosua Serwaa say or no na or best wa a burden in na say on proving ordinance marriage no, or because say wakoka say on it Lumba worry. Say, I dance for the by no san for proof baby on the embra. Enu no mubisa in the court of appeal enhwe na ontwa sa nsem ni mu. 2. The learned trial judge erred in law in her interpretation and application of sections 136 and 161 of the Evidence Act 1975 regarding authentication of foreign documents. Let's say wo hwe kwan first authenticating foreign document temwafo no yemfunso o mrem esan say said your one year nenka sa pepepe enti die enti na temwafo no be kan say Akosua Serwaa no lawyer for man ntimi anye authentication enti emrem no temwafo no ayemfunso eno so mo de ho ehhye nyina aba ebi omo kire say the learned trial judge erred in law when she failed to hold exhibit B1 and C to be presumptively authentic despite the respondent having had reasonable opportunity and time to investigate the authenticity of the said document. Kire say temwafo na yemfunso pa kase wo mremu kire say adanse omde ba ye B1 ni C marriage certificate ni wa adanse pictures na ade na omde ba ye no respondent ni mo mbre mo koye investigations authenticating na enti say temwafo na anya ntumudi a ene na yemfunso pa wo temwafo na fa. The learned trial court judge erred when she held that the marriage certificate exhibit B1 and C were not admissible per se. Say one more the marriage certificate about what to need exhibit B1 and C. Not just also want to mean to mudia and na no no one more tia say ye ntembremuno temwafo na yemfumso enti abusua we mo ene ensem bebre no mudia gun krata so a Maami Akosua Serwaa na lawyer for ede kodan appeals court ne say wo mo hwe no mo ka bi ma no esan say atemu a Justice Dorinda Smith ata ede ba ye be ye say han odobro ni Akosua Serwaa ni na ye ware wo mo wa mamre kwan so ebi Lumba ne Maami Akosua Serwaa adanse bi ede so mo ware wo mra kwan so ni ntino be ka so no nkuto na yere no wa batu agu ni santem ni na no court no hwe no ontwam no mu atemfu fo kran fo Maami Akosua Serwaa san say adanse ne niam mo de ba be kire court nyina kire sampa pa ni nuane pa Maami Akosua Serwaa Charles Kwadwofo Sudan Lumba ware no wo emra kwan so enti abusua we ne ensam a sabredi eboboba na emum de di mu akotere pa kese pa ne se Maami Akosua Serwaa sabredi na lawyer Kusi wasake no wakọ akwakofa Kulendi at law lawyer Stephen Insia Opoku se wono eneme gira na namu na ondi asem kai se Kulendi Justice Yodi Kulendi ono ya Supreme Court judge na nado dan Akufo-Addo boni di ne be Supreme Court judge kese pa Justice Kulendi so oyobi a osua mra di mra wo na Akufo-Addo ni chambers anya asem ketwa nei na Akufo-Addo kire na ade ne ade a wa be Supreme Court judge kese pa wo Ghana enti ono ni chambers na Steven insi opoku adwuma saa be de mame Akosua Serwaa akɔfa no se omra na omedi anim na na piu no onkonko yamantie bia na odisa piu na amaso a we na ba so na information a yetete kire se ɛda no on the 11th of June no abusapeni lawyers ene lawyer fo aka no respondents no omo lawyers no nyade so mbekwa kopie mu ewo court honum esan se wo mo kire se wo na se wo san lawyer wo mo si yo mate emra ma ho kwan se san lawyer okoya amendment a emra ma ho kwan se amendment enti wo mo nyade so mbesi court on the 11th of June enti ye ready say on the 11th of June no ebe kopie mu ewo Kumasi High Court na ensemi yakotie bi na yakohe ba bi ebekwa kowie so court no be ma kwan se Mame Akosua Serwaa the lawyer no on sesa no anase on sesa no court ne ma kwan a amendment a wo hwehwe no so no court no be ma kwan ama wa yes amendment ni nyina na emra ma kwan na emra ma kwan ni nyina no ye bekọ akodi akire enti sabe de Mame Akosua Serwaa versus abusuapeni Kofi Owusu Presilofori and afin so no transitions funeral home no enya enwie kra afei na ahyase ebisi afei na agro no ahyase gidigidi be free maba bia no ye de beba aba beda me da se oje bre na otena se tie nchirichimu amde be nyina wei court nkrata ide nyina agu emfoni hwehwe fidie no so a wonso hunu ni nyina bi enti se odo comment ba no ma nwate na bia kama midin ede nkrofo da Serwaa Oheneba Media ye fa sida kese asida chinchincha sida mu dru asida PSA ma tap send womo ene boye chidom ne adon meet na se ede sa ensemi nyina no ebeda mo oni omu ni dwa na bia nye come on download ya Play Store and ase App Store no download the tap send promo code no Oheneba bo shema benya bonus ni bi aka osika ho na bibia atumi kama na ikwa the promotion course am say win 100% cash back win 100% cash back enti wonomu ni dwana bibia enye kama makra mu nyina
Oheneba Ejeni Makonie the CEO of Oheneba Media menuanom Ghana fo a mo wo Europe UK Canada ene America ene me wa sempa bi de ma wo se wo pese wo send ska ema wabusuafo ene wadofo wo Ghana ene na tap send ya na me kamfo ama na de ma manigi omo kura ne se omu rate was through no charges afi wasabo sika ho ban ma wo say mobile money accounts ana bank account ana wo send this kana kotumu a sima krope na wonsa kan wo Ghana de wuya ne say obefa wo mobile phone no akọ Play Store ana App Store no download tap send app no egu phone so kayo say wo send dia obebusa wo promo code eno ane say wo do Oheneba keke no ahye ho wo Europe a obema wo €5 wo UK obema wo £5 o America ne Canada so a ubenya $10 Oheneba keke nti na mo am wo UK no kra de me wa sem de bi de mamo ubetimi create wallet account e wo tap send wo so ebre bia rate ne be kosoro no o dia ne se ube save ska wo ho na ebre pem no se wo Ghana no be bia wo bia no na wo de wallet account no ato de opese wo de to bia tap send papa no
Oheneba Media for na efremu ayebo me alise Media Royals Media mu adehye no asiebo ana enta semana amamla ni amane mu dwumadie Oheneba Media betenete enti amanfo mu ntie ye na nyado